Good morning and welcome to Legacy Planning with local attorney Steve Waltar. Legacy Planning is committed to helping you provide personalized and compassionate estate planning to help you organize and transfer your estate smoothly with minimal taxes, costs, and hassles. Steve has the mind of an attorney and the heart of a pastor, and he'd love to take your call this morning to answer your estate planning questions. The lines are open at 1-800-955-8200. That's 800-955-8200. Now, here's your host of Legacy Planning, Steve Waltar.
Good morning, Seattle and Northwest. In fact, should I say U.S.? Last week we had some callers from Pensacola, Florida, and we had Michigan, but my daughter's not on the phone with me or in the studio with me this week. But if you're listening anywhere, I want to welcome you and say we are live and local. We would be happy to take your calls. We're at 1-800-955-8200. That is 1-800-955-8200. This is a unique day because I was actually thinking I was supposed to have a crew race. I get up, at 4 a.m. 3 times a week, and I'm out on the water. And we had a special crew race scheduled today. And my wife pre-ordered some donuts, so I went and I felt bad. Like, okay, even though the race got canceled, it was going to maybe affect a little bit of the radio show, but we worked that out. And anyway, I decided I better go pick up those donuts. Instead of 2 dozen, I decided to do 1 because they weren't even ready at Safeway. Anyway, so I was getting on ready. I live over in Kirkland, so I was going to drive on over here. And I saw that a cop had pulled someone over. And I thought, oh my gosh, someone's having a bad day. It's rainy, it's jucky, whatever. So I decided to pull over and perform a citizen's service award or something. So I went, and I was still eating one to show these are not poisoned or anything like that. So I went and offered the police officer a donut as well as the person he pulled over. They both declined. But it was pretty funny. And then, getting near the studio here, I usually have breakfast at Jimmy's on first. And then, I saw some people waiting for the bus, and I started thinking about Jesus, at the wedding. He invited all the good people, and then pretty soon no one would want it. So, he went and said, hey, anyone come. So people are at bus stops, and I'm offering donuts anyway. So I brought him in here today. So the lunchroom will be filled with donuts, and my producer will get a donut. But if indeed, dancing in the studio, if indeed not too many people eat them here, I think maybe I'll snatch a few back with me because tomorrow my wife and I are finishing a class called Financial Peace University. Boy, if any of you have heard of Dave Ramsey and Financial Peace University, I highly recommend the class. And not just because they say you should have a will. It's just good about financial discipline and learning about our country and marketing and credit and debt. And I tell you, as an estate planning attorney, I see it when there's crushing debt that affects the loved ones after you die, in probates, when you have to pay off the debts. A lot of stuff like that. So if you want to talk about finances, estate planning, things like that, go ahead and feel free to give us a call at 1-800-955-8200. I'll give that number again, but today I'm flying solo here. So would love to have your calls at 1-800-955-8200. Now, I do get, from time to time, an email to radio@waltar.com. That's radio. And then it's my last name, radio@waltar, WALTAR.com. And that can work during the show. I've kind of got a few screens up here, so I'm trying to be able to view an email if it comes. But it also, if you want to reach me during the week, that goes to my law firm. I'm able to see that. I logged on today. It was kind of cool. I've got my website up. Let me just list a few of these things. Let me jump over here, go to reports. While I was here waiting for the show to start, I looked up, there are all sorts of reports available at waltar.com, okay? And like special needs planning, aid and attendance, that's for people that serve during a period of war. I'm an accredited veterans attorney. Are your bank accounts safe? There's an article, a report on FDIC insurance. Asset protection, beware of living trust scare tactics. Charity begins at home, creating a lasting legacy. The best things in life aren't things. I recently had my parents on, and I hope you enjoyed that, as we started talking about what motivated them to do planning, and they have charitable planning as part of their things. The dangers of do-it-yourself wills and living trusts. So anyway, you click on any of these. It's real easy. I've already downloaded it. Just put in your name and email, and we'll send you a free report. That's at waltar.com, WALTAR.com. So I like to kind of summarize this week in planning. So let me tell you a little bit about my week, because this last little report, doing it yourself, wills and trusts. Even at breakfast, I saw an article, on the TV is a LegalZoom and all that stuff. I've had a lot of clients come into me because they weren't comfortable about what they did with LegalZoom, and they have me review it, and pretty soon they hire me to do their limited liability companies and their S corporations and, of course, their wills and trusts. So I had someone who came in and this week, and he had done a will. He was divorced, less than a decade ago. I won't get too specific. He knew that he ought to do a will, so he bought a Quicken Will kit or something like that. Well, every once in a while I see the wills don't have the right magic language. Often when someone does a will, I saw it twice this week, he and someone else, where they had a will that says, I give everything equally to my kids, but if one of the kids dies, then it skips the grandkids and the surviving child gets it all. That's usually not, at least in my experience, that's usually not what people want. People love their children, and people really love their grandchildren. So if you have a child die before you, and it's tragic, I'll go months at a time, and during my consultations, right? I mean, you understand how this works. I pay for this time, right? I pay for this radio show. This is your chance to call me at 1-800-955-8200. That's 1-800-955-8200 and get free legal advice today over the radio on estate planning. So, during my consults, I'll go weeks at a time, and, people have good relations with children, bad relations, some estrangement, but every once in a while, kind of seems to come in groups. There are people whose children have passed away before them. That's a tragedy. That's really not the way it's supposed to work. We have a loved one die, in the next generation before the parent. But most parents would want that child's children, if they had any, to get their share. So you got Johnny and Susan as your two kids, and Johnny passes away. Susan would still get her 1/2 share, but why wouldn't Johnny's share be divided equally among his 3 kids? So when you do it yourself, you probably don't know the right language. You probably don't know what is per capita or per stirpes and share alike and all this stuff. So that's just one highlight of, the person didn't like their own will. I pointed out some of the issues. I see countless times that the healthcare power of attorney doesn't work. We talked about this before. A lot of healthcare powers say no one can make any decision until a doctor says in writing that you're unable to make your own decisions. Well, let me ask you, if you're driving down the road, you're having your morning coffee, think about this. Can you give authorized consent the very moment you're incapacitated? You cannot. And I can write a document that says that, but it's not HIPAA compliant. HIPAA is the Healthcare Information Portability and Accountability Act. It protects privacy. When I give seminars, I usually tell the story, but why not tell you now? There was a guy who, this was in 2004, and if I look out, I can't really see that part of Seattle here out the window, but a guy lived up on Capitol Hill, called Pill Hill, and his mother passed out. And so he quickly, drove her to, I don't know if it was Swedish or Virginia Mason or Harborview. He drove her to the hospital and immediately took her to the ER, and, they rushed her in and got the gurneys and, blah, blah, blah. And so, his heart's been pounding. Finally, he did his duty. He dropped his mom off. So he went and now parked legally, wherever you can park legally, right? And then he came back and he said, how is my mom doing? I want to go visit. I want to check up on her. And they wouldn't talk to him. Why? Because he didn't have a current healthcare power of attorney. There had not been a HIPAA release signed. This made the front page of the Seattle Times back in 2004. I might be wrong. It might have been 2005, but anyway, I wish I'd have saved that article. And thousands and thousands of estate plans, powers of attorney, were blown up because of the HIPAA rules. And it affected living trusts as well, right? Because of sometimes privacy issues. What the concern is doctors and hospitals, they don't want to be liable for a felony, $50,000 fine, by communicating with someone that doesn't have authority. Now, let me stay on this a little while longer, and then I'm going to do what a bunch of listeners have told me. Steve, why don't you define a few terms? Why don't you kind of educate us a little bit? So I'm going to, I can't give an entire seminar during this radio show, but we do have a report, and unfortunately, I don't see it on the dozen reports or so that we have on our firm. There is something called 104 commonly asked questions. And so I'm going to probably just kind of work through that a little bit and kind of give you some Q&A, do a little bit of teaching here. Because many of you have asked for that, and I thought, hey, some people will call in and then they'll ask a question and then they'll hang up. It is not wrong to be on the line with me. I'm happy to take your calls. And that is again today at 1-800-955-8200. That is 800-955-8200. So I got to think of my train of thought here. I was talking a little bit more about the healthcare power of attorney. What about if a husband and wife are don't have a healthcare document, and let's say husband goes in for some care. Now there are statutes about who has visitation, and of course, gay couples also have visitation. We've changed some rules in Washington, and I think it's a good idea that people have the right to visit their spouse in the hospital. But what wife doesn't have authority to make a health decision for her husband or vice versa. You can't make a health decision for each other. What the doctors and hospitals are worried about is what if they, are somehow convinced spouse says do something, and then husband eventually recovers and he differed with his wife's opinion because he had not pre-signed an immediate healthcare power of attorney. They are subject to litigation. So if you're concerned about what kind of documents make sense for you, married or not, you should give us a call at 1-800-955-8200. We'll be back after your break to talk about this and other important estate planning matters.
Legacy Planning. Legacy Planning with Steve Waltar. Has it been over 5 years since you've reviewed your estate plan? Well, the laws keep changing. You'll definitely want to keep listening. The lines are open at 800-955-8200. That's 800-955-8200. Legacy Planning. Live and local. This is Legacy Planning with Steve Waltar. Wondering if you really have complete, up-to-date estate plans? Call Steve right now at 800-955-8200. That's 800-955-8200.
All right, so we are back. We're back. We were talking about healthcare powers of attorney and HIPAA, and if you don't have good documents, you may be heading to court, and that's while you're alive. So that is anyone out there who's an adult should have accurate powers of attorney. And I think I had a lot of callers recently, young Christian gamers, and they thought, oh my gosh, I'm certainly not ready to die, but I'm not too worried about that really for the 20s and 30s, but you should have powers of attorney. We don't all need living trusts or wills, but we all pretty much need powers of attorney. So at our firm, we design plans that fit the needs of our clients. Well, let's move from incapacity planning to death planning. Again, this is kind of a little overlap of my week in estate planning and some common questions that I get. So a lot of times people say, Steve, what happens when you die? And actually, I had someone come in this week. They'd been to a seminar, and they wanted to kind of ask me a bunch of questions about their parents that both died out of state. And I was polite, and I answered a few questions, but really, you need to deal with an attorney licensed in that state. So probate is the legal process of retitling things. So if you die without a will, think about it. What's that called? It sounds painful to us men out there. It's called intestacy. Yeah, if you die without a will, the state has a will for you. Well, let me talk about what that would mean. That would mean that if you have children, everything would go equally to your children. And sometimes you don't want things to go equally. There's nothing as unequal as the equal treatment of unequals. So it might not be great. Plus, you will not be able to, without a will, say who is in charge, who's the executor or the personal rep of the estate, and you can't say that they can act without bond. So I often say that intestacy is just Latin for big attorney fees. If you die without a will, yeah, the state statute has an intestate rule about who gets what, when, and how. So, I mean, maybe if you're an adult and you'd want everything to go outright to the children, it may not be wrong. It may not go to the wrong people, but it does not go efficiently. I usually charge a flat $1,000 more, $5,500 or north of $5,000 if I'm doing an intestate probate. If at least there's a will and it says who gets what, when, and how, and we're not going to have the court's what we call intervention or interference in some ways, oversight, then it's cheaper. It's cheaper to administer a probate if you have the right language. So when I review wills, I very quickly can see if it has the right magic language. If you moved here from another state, you really should review the wills because a lot of states don't have the magic language that Washington has. Well, let me change the situation a little bit from a simple adult dying with adult children. Let's say that there's a husband, wife, they get married, have a couple of kids, they divorce. Now, that happens almost 52% of the time. When I did wills and trusts back 20 years ago, I thought I did great wills and trusts, but I've been practicing long enough that I've seen that divorce implodes estate plans. It really does. So we do a lot of things to fix that now. Well, let's go on with my story here. So husband, he ends up with a house. Wife gets other accounts. They do the quadro. They split up the retirement, et cetera, et cetera. Husband now goes into, and what happens? Remarries, right? Guys need help. They need a spouse. Okay, so we get a remarriage. Now he has another child or two with the new spouse, okay? So a few years goes by, and he dies. He dies without a will. Okay, so he dies intestate. So there's certain assets that are joint and community because they did them together, but he brought that separate property house into the marriage. Even though we're community property state, this is really important. Your assets do not automatically go to your spouse. And they do not go to your spouse without a court process anyway. So what happens here, we have an intestate probate, and the intestate laws are going to say that one half of that house should go to his current spouse. Guess where the other half goes? It goes equally amongst his children. So now he's got children from marriage 1, children from marriage 2, all children. You add them all up and divide that by however many they are, they together own a 1/2 interest in that home, along with the new spouse. So depending on the age of the children, you might have spouse number 1 and spouse number 2 and maybe even a child. You have all these co-owners. Is that a good idea? That is a recipe for disaster. That is a mess. That's what happens if you die intestate and you've got some separate property and kids. It's just a mess. And, frequently you have someone that maybe they make it through 10 months and $10,000 of a probate, pretty common. There aren't set fees in Washington. So often people want to do a will. Let's talk about a will. A will is an instruction. If you hire an architect to build a home, they do a blueprint, right? I mean, it could be a fancy program. It's usually not on the drafting paper. It's now computer stuff, but it is a blueprint, right? My point here is, does it build the home? No, it doesn't build the home. It's instructions on how to build the home. You still have to hire construction people. They lay the foundation and put up the walls and, the sheetrock and painting and electricians, right? Same thing with a will. If you come in and you ask me to draft a will, it's great. I can draft a will. It can be short or long, complex, simple. It can be all sorts of things, but it does not control your estate. You have to wait until someone dies. So when you die without a will, that's intestate, right? But now if you die with a will, it's the legal process of taking care of things. So probate is a Latin word that means prove, to prove who died, and then to give notice. When we do a probate, we can't just file a will downtown. We have to do a petition, an order, an oath. There's usually a notice in a paper. There's notice to the Department of Social and Health Services because they want to be repaid, especially if there's Medicaid or something like that. So it's a legal process to kind of notify everyone, notify the creditors. There's a waiting period, and usually the waiting period is, at a minimum of 4 months. Because people can contest the will, creditors have a chance to be paid, and then eventually you do distribution. So probate is really the process of retitling. Does that make sense? Yeah, so when you die, not all assets go through probate. This is another kind of good and bad thing about wills. They don't control the whole estate. If you have an IRA and it says, I give that to my children or my spouse, it doesn't go through court. But the house does. You better believe the house does. Title items like cars are supposed to go through probate. Sometimes if there's one spouse that dies, I'm a realist, you can often go to the Department of Licensing and get the car retitled. It's supposed to be through the court process, but a lot of times when a spouse lives, it's really just fine. So probate is the legal process of retitling things, getting your name off, paying off the creditors. Paying creditors is actually one of the purposes of probate. And why is that? Because when you eventually retitle, things, or if you sell a property, you want to make sure the buyers have good, clean, legal title. You want to make sure that works. You want to make sure the beneficiaries have something and all the debts have been paid. I believe we're going to take a call, and this is it Lois from Tumwater?
Yes.
Go ahead, Lois. You're on the radio.
Oh, well, I'm a little old lady, 87, and I don't really have anything except an old pickup, 99 pickup that I own free and clear. I don't have any bills, but I don't have any property or anything else that I have my name on, and I live in a little house on my son's property, and I call it my mini mansion.
Your mini mansion, okay. So you do not own the home. Your son owns the home, but you own a car and maybe a bank account, something like that?
I have a bank account, but I have my kids' names on it in case something happens to me.
Okay. Thank you for calling. So let me talk, and you can stay with me as long as you want. So you probably don't need to have a will, because there's not going to need to be much of a retitling when you pass. But let's talk about these accounts. So when you say you have your kids on the accounts with you, what do you mean by that?
I mean that if something happens to me, they have the power to go in and use it.
Okay. Well, let me tell you what you may have, and then I think I might have a better way. So frequently people want the kids to have access, they don't want a big hassle, and they don't want a court process when they die. I agree with you on all of that. But the problem is if you add one or all of your kids to the accounts, if they are actually on the statements with you, you've created something called joint tenancy. That sounds weird and technical, but the problem with joint tenancy is what if any of your kids got in a car accident and they were sued? They technically own 100% of your bank account. So you could lose your accounts because you've added your children to them.
Oh, my.
Yeah, so that's not a good thing. And actually, those that are listening and want the report, The Trouble with Joint Tenancy, it's on my website, again, at www.waltar.com. So, Lois, a much better way would probably be for you, if you can, it's kind of hard, but if you go and you're really careful and you talk to the right manager at the bank, you might be able to have signature power only. It's like a miniature power of attorney. I mean, certainly you could do a power of attorney saying they could sign. That would be very good. You want some way they could sign, and then upon your death, you can do something called payable on death. You can say, when I'm gone, it's like on that little beneficiary card, you say, when I'm gone, it goes equal to your 3 or 4 or 2, however many children do you have?
2.
2. So that's fine. You can go payable on death with that checking account. So that would be a way to make sure that when you die, it goes to them with no court, no worry about a probate, but you are not going to lose the money during your life because something happened to them and they were sued.
Oh, man, stuff gets technical, doesn't it?
Well, you're not alone out there, Lois. This happens. I have lots of people that add someone to an account. Now, if your account, it's less than $5,000 or, I mean, sometimes I'm not too worried about kind of small convenience accounts. But I would say you'd be better off if you could do a power of attorney and say that your kids, one, and then the alternate could sign. You could say that they have the authority right now to sign on your behalf, but then if they're sued, the creditor can't take your account. So it's often better to say, look, I want management during my life. I want probate avoidance when I die, but I don't want to all of a sudden say it's a free-for-all because I bet you that bank account's pretty important for you.
Well, I don't really have much in it.
Okay.
I mean, I really have my monthly stipend go in, and I use it, and I do it again the next month.
Well, let me ask another question, and if you want to, what kind of work or employment? What do your kids do for a living?
My daughter is handicapped from an accident, and my son works for IBM.
Okay. Well, I'm glad you shared that, and I'm sorry about the accident with your daughter. If she's on that account and the state agency learns that, it might be that she'd be disqualified for certain benefits. So you want to be kind of careful. I'd say it's better not to have her on the account. And then with your son, since he doesn't own his own business or practice, if he works for an employer like IBM, it's kind of unlikely that he'll be sued. So maybe it'd be okay to just have him. It'd be better, to be totally honest, it'd be better if your son had a power of attorney and he was not on the account and he was just a payable on death beneficiary, and then maybe you trust him to even care for your daughter. Do your two kids get along pretty well?
Oh, yeah.
Okay.
I mean, he's as honest as the day is long. And he would give more and keep less.
Yeah. So let me summarize again. It's a little dangerous to have everyone on the account with you. It'd be better to be payable on death. And I think the payable on death to your son would be the cleanest to not disrupt any of your daughter's possible benefits or anything that she's, any of her needs. Is that helpful for you?
Yes, it is, because I thought I had things fixed.
All right. Well, I thank you for the call, and if you want, you can go to our website at waltar.com, and you can have your son, type in the trouble with joint tenancy. It's in our free reports section.
Waltar.com. And what was the name of the...
It's called The Trouble with Joint Tenancy.
Okay.
I just downloaded it, I believe, while I was on the air. See, I'm the special needs planning. You could download that one as well. I don't know if that would affect your daughter or not.
Well, I don't think I have anything except a little bit of furniture.
Yeah. Well, I thank you so much for the call. I think what we'll do is probably go to a break here, and when we come back, what I want to do is I want to talk about trusts. So we talked about powers of attorney, we talked about wills and probate. I think it's good to say what's a trust, what's a legacy wealth trust, what's the difference, and who should benefit. We'll take your calls after the break.
Do you need a will or trust or no planning at all? You're listening to Legacy Planning with Steve Waltar. Join in the conversation at 800-955-8200. That's 800-955-8200. Legacy Planning. You're listening to Legacy Planning with Steve Waltar. Join in the conversation now at 800-955-8200. That's 800-955-8200.
All right, so we're back, and we did have a caller before the break, talked about the trouble with joint tenancy. That's the problem when you co-own things with children. When you start adding them to your accounts, thinking you're doing some nice management or letting them manage things for you. The problem is you're adding their creditors to your account. So I did look on our website. If you want, go to waltar.com, that's WALTAR, and go under the reports, and then the trouble with joint tenancy. And you just a couple of clicks, put down your contact information, your email, your name, contact info, and you'll be emailed that report. So I said that we should probably talk about what are living trusts and what is a legacy wealth trust. So in short, a trust is, they've been around 1,000 years. They were kind of a way to get around the king's court and all the extra administrative costs in England and things like that. So a trust has three people. Trustors, they're the ones that create it. Trustees, they are the managers, and beneficiaries. Okay, that's who gets to enjoy all the benefits of a trust. So my wife and I, we're the trustors, trustees, and beneficiaries. Now, you obviously, anything you can do in a will, you can do in a trust. So obviously, my wife and I, we have backup trustees. I'm lucky enough to be able to list our parents, my parents, as backup, and then siblings and things like that. So you don't have to involve banks and trust companies and stuff like that. And of course, for either single individuals or married couples, you can be the beneficiaries right now. And who are the backup beneficiaries? Well, you tell me. It's often the children and the grandchildren and the churches and charities and all of your causes. Again, anything you can do in a will, you can do in a trust. But the big difference is, remember, we talked about before the break, we talked about wills and probate. A will doesn't control everything, and when it does get around to controlling things, it controls it through court. All right? So you file and do a petition and order an oath and all that sort of thing. Remember to change title. Well, a trust works kind of the opposite. You remember the old phrase in the commercials, right? You can pay me now or pay me later. Was that Fram or oil filters or something? A trust is generally more work and cost up front. Although there's a couple of attorneys in my own Rotary group that charge just as much for will planning as they do with trusts. So in a trust, what we do is we get things organized. So we deed the real properties into your trust. We do that now. Right? So when someone signs a trust plan at our law firm, they sign the trust, powers of attorney, healthcare, HIPAA, all these sorts of forms. They even sign a new will. Why? To revoke an old will. If they have minor children, to list guardians. And also to be what I call as a pour-over, a catch-all. Think in terms of belt and suspenders, right? A will is the backup tool. What if you didn't tell me everything or not everything got into the trust? It's really nice to have one more chance to get it in there. And for married folks, we have something that's even more efficient. There aren't many firms doing that in our state. You can do a community property agreement that pours over to the trust. So this is a little technical, but what if you live your life and you do some refis, and even though we offer a free review every 3 years, what if when one of you dies, there's an asset that you don't have in the trust? At our firm, we plan so that we can still avoid court, get it all to the survivor, get a full tax step up and all that stuff. But what if when the survivor dies, or what if you're single, there's a wrongful death lawsuit or something you have to litigate? Well, that's why we have a will. The will is to say, look, bring any legal action, collect the debts, do that sort of thing, or collect the windfall, I guess, in that case. And then the only beneficiary of that pour-over will is the trust. So I hope that's a good summary of a trust. Again, 3 people, 3 kinds of people involved, trust or trustee beneficiary, and then it's you fund it now. You either own things in the trust or you make things payable on death to the trust. The only asset you cannot own in a trust is tax-deferred stuff, like an IRA or a 401k. You don't want to own it. You don't want to take your name off and trigger an income tax. But guess what? You can say that the beneficiary of those policies is the trust. And then that's our job. That's my job, is to draft the trust that would still stretch out all of the tax-deferred payments over the life of your beneficiary. Pretty freaking powerful. That's really, really good. So if that's a trust, now let's talk about different kinds. I mean, what is a revocable living trust versus a legacy wealth trust? Okay, first of all, we've talked about what's a trust. Some trusts don't work because they're not funded. They don't own things. All right, I had a call one time from someone, and she was the oldest of 8 children, and she lived in Bothell, and her mom had a trust, so she called me, didn't even want to come in for a free consult. She just called me and said, well, my mom had a trust, there's no probate, right? And I said, well, can I ask a few questions? Well, sure. I said, did mom own a house? Oh, yeah. Well, was that house titled in the name of the trust? She says, oh, no, it was in her own name. So then I said, well, did mom have a brokerage account? Oh, yeah, she had some mutual funds and a brokerage account, and, it was worth $400,000. And I said, well, was that titled in the name of the trust? And she said, no. And so it took a while for her to believe me, but I finally convinced her that trust was empty. That was an empty box. It owned nothing. It controlled nothing. And so kind of was messy to do a probate for the 8 beneficiaries. So one of the problems with trusts is if they're not properly funded. But what if a revocable trust is properly funded? It owns the homes and businesses and stuff like that. One of the problems with traditional planning is it gives everything outright to the kids. Well, okay, most kids, what if the kids are over 25, they've been through college and they have a job, but what if they get a bunch of money? What if it even avoids court? What if it did that, but then the kids go through divorce or the kids are in a lawsuit or something like that. So a legacy wealth trust is a trust that avoids court, but it also provides protection for the next generation or two. So that's one of the differences. I'm not even reading anything in this nice booklet that I have. If you want, you can call our firm. So our firm number is 425-455-6788. That is 425. We're in Bellevue. 455-6788. Call and just request the 104 common asked questions. Of course, we'd need to know either your email address or, better yet, your mailing address and your name, and we could mail you out that. So a legacy wealth trust it's a document that has a living trust at its core, but it's drafted in a way to avoid court during your lifetime, to avoid court after you die. For married folks, it doubles the tax exemption. Maybe in the last segment today, we'll talk a little bit about taxes. So Washington State allows you a little more than $2 million. So in 2016 here, they allow you $2,079,000 before there's a tax. But if someone dies and they got like $3 million, you're taxed at 10% on that extra million. So that'd be a $100,000 tax. So for married folks, a revocable a legacy wealth trust can double the exemption and protect more than $4 million. Federally, it would protect more than $10 million. And the other thing is, legacy estate planning is about more than just assets. Traditional estate planning, it talks about accumulation, preservation, not so much. I mean, it's really about divide, dump, and dissipate. I think legacy wealth planning is how do you protect the next generation and how do you provide for the non-financial things, right? How do you make sure that your heirs know about your life, your contributions, your values? How do you capture those treasured things? You know, one of our booklets says the most important things in life aren't things. So legacy wealth planning, it avoids court during your life and death, but it also provides protection for your heirs. You know, I often ask people, when are you going to know if you had a good estate plan? Well, you probably won't, right? It'll probably be the children or maybe the grandchildren, right? Someone is going to learn about that. And by the way, before we do a break, I have seen a lot of deaths. I guess I haven't seen them, but I've seen the aftermath. When the kids come and they're like, oh my gosh, we got to go to court, and oh my gosh, we got to do this and that. I had someone in again this week, and they're like, oh my gosh, I went through this with our mom, now we don't want to go through it with our dad, tell us what to do. And so we often design plans to avoid court. Well, we've also been around and helped enough families that every once in a while the kids say, boy, I just wish I could say thank you. Thank you to mom and dad because they really made this pretty easy. That's what a legacy wealth trust plan can do. How can you get things organized now, keep you out of court, keep your children out of court, give them protection and guidance for their life, and capture the non-financial stuff? Well, that is pretty powerful stuff. So let's transition into taxes. We're going to take a break here. After the break, what are the rules for taxes? What's a step up in basis? What can you do to avoid taxes if you got a good sized estate? We're going to talk about that when we come back.
Legacy Planning. You're listening to Legacy Planning with Steve Waltar. Is there ever a good time to do estate planning? Ask your kids. They'll know that right now would be the perfect time. Call in for the right answers at 800-955-8200. That's 800-955-8200. Legacy Planning. This is Legacy Planning with Steve Waltar, committed to helping you with personalized and compassionate estate planning. The lines reopen for your call at 800-955-8200. That's 800-955-8200.
All right, so we're back. We're back as in I'm back. This is Steve Waltar, and this is Legacy Planning, and this has not been too bad. I'm here alone in studio. I don't have a guest today, and it's the time's gone pretty well. We've done a lot of things today talking about what is estate planning, what do I do for a living? I do estate planning. I do wills, I do trusts, I do free initial consultations. And today we've given out some reports, we've given some advice on the trouble with joint tenancy, probate, what are living trusts. So I will give my website again, and then I'm going to talk about how do you reach us during the week. So Waltar.com. You got to spell it Waltar. So www.waltar.com. So the other way to reach us is radio@waltar.com. That's the way to email us. Then we know that you heard us on the radio. And then I would say, if you are at all interested, I haven't even gotten to reading any of these things, but we have a report entitled 104 Commonly Asked Questions that we often give out at seminars, and it even includes questions on Medicaid questions and things like that. So if you're interested in something like that, if you're interested in a free consultation, if you'd like one of our questionnaires, we have 2 questionnaires that we give out to people prior to giving a free consult. One is called an estate planning worksheet. If you want questions on who might you list as your power of attorney or your health care, that's the right one to do. If you've got minor children, you want to list a guardian, then the estate planning worksheet, we're happy to give that out. For most people, we give out what's called the estate planning questionnaire. I think it's a little easier of a tool to kind of characterize how you own your assets. And, when I give a free consult, I need to know if you're married or not, if you have children or not, a little bit about your assets so that I can I can explain things. So, again, radio@Waltar, that's WALTAR.com, or call us during the week to 425-455-6788. That is 425-455-6788. I believe we've got a lot of our radio shows now up on the website, so you can even listen to past ones. We've done it on funeral trusts. We've had a couple of accountants on. We've had some financial advisors on. More and more, we're going to provide you those resources. So I want to talk about taxation. So, I'll just give you the rules and then we'll talk about this. So the federal exemption's pretty large. Technically this year it's $5,450,000. That's a lot of money. For argument's sake, let's just say it's $5 million because it's going to be easier to talk about. And the state of Washington exemption's way lower. It's $2,079,000. But for today's purposes, let's just say it's $2 million. So we got $5 million at the federal level, $2 million at the state level. Let me get your attention on this. If you are married and you did documents in another state, frequently people move here from California, right? And to get out of their traffic and into ours. So at any rate, if they did a will and says, it's a will or a trust and had the right tax language, if they come here and they don't have it reviewed or checked, there's a chance, there is a serious chance that when one spouse dies, the survivor might have to pay $240,000 or more in taxes. Why? Because you can only give $2 million and change to your spouse in Washington. So there's lots of things you can do to legitimately, legally reduce or avoid taxes. One is if you're married, come in and see an estate planner like myself, and you can avoid taxes in a will that has credit shelter trusts. Or better yet, why not avoid the tax in a revocable living legacy wealth trust? Why not avoid 2 or more probates? My wife and I, with our legacy wealth trust, we avoid 4 probates because we've got real property in Washington and also in another state. So if you've got a timeshare, you got property out of state, if you're going to inherit part of that farm elsewhere, my gosh, why not do a trust? So taxes can be avoided by proper planning for married folks. Oh, and I just have to say this. So this was funny. This was really cool. A couple of weeks ago, I had a couple in good size estate. Okay. One spouse had one person. I won't say male or female. Yes, I will. The male had north of 5 million, and the female had really, maybe around 1.5 to, I don't know. It's kind of a good size estate, but not as large as the man. And they had been together, they were so proud, 36 years. Not married, still together. And I was able to meet with them and explain how they could do, yes, they could do a joint trust, they could do separate planning, they could do wills. But I said, if I do that, we got to really be careful because I want to get into gifting. You can only give a limited amount to someone who's not a spouse. Okay? So there's $14,000 a year you can give to as many people as you want. I often say at a seminar, Bill Gates could write a check to everyone in the U.S. for $14,000. And I could write a check for $14,000 to everyone. They'd bounce, but I could write the check. But if you give more than that, you've made a taxable gift. So the really cool thing here was I said, look, it was clear they wanted to do a joint trust. They wanted to be able to act as if they were married and sign for one another legally. And I told them, well, here's the fee if I do it this way, but I got to charge extra because I got to remove all this tax language, be really careful. Or you can probably save, $1,000 or something if I do the planning and you decide to get married. It's not my job to tell them that they ought to or ought not to get married, even though I've done some pastoral counseling. And anyway, by the end of the week, there was a call back and they says, yes, we're getting married. And I thought, woohoo! I was able to help a family decide to get married. After 36 years of living together and being really wonderful to each other, they decided, yes, let's get married. So married folks, you can do all sorts of things. For people married or not, there are the annual gifts. So like I was just saying, you can do gifts of $14,000 to as many people as you want. And then you don't even dip into your federal amount. Washington State, this is huge. Washington State has no gift tax. So sometimes it makes sense to give a large amount, hundreds of thousands of dollars, even $1 million or more to children while you're alive. That will not affect Washington. So you get out of that, if you're north of $2 million, there's something you may want to do. Of course, you can do charitable things. Absolutely. And we're going to have on more guests about charitable giving and things like that. There's also something called portability. That has to be figured out after someone dies. But the Credit Shelter Trust, I think, is more powerful than portability because you can have remarriage protection and all that good stuff. So estate planning, we've talked about simple wills. We've talked about probate. We've talked about living trust. What is a legacy wealth trust? And now estate tax planning. We do it all at our firm, and we do it more than on the radio. We do it all week long. So we would love to have you give us a call at 425-455-6788. That's 425-455-6788. And we will help you with estate planning. If you'd like to set up a free initial consultation, that is what we do for a living. It's free. It really is, but we want to be organized. So we will send you a questionnaire and directions to our firm. And then if you choose not to hire us, that's fine. Most people that take their time and come in and see us, they just want to design a plan that fits them. I tell people at my seminars, look, when you come in, it's not about, Bill and Mary or Homer and Marge Simpson or anyone else that I may use as an example. It's about you. Take advantage, give us a call, come and see us during the week. I thank you for listening to Legacy Planning, and we'll be back next week. Have a wonderful week. Take care, and God bless.
You've been listening to Legacy Planning with local attorney Steve Waltar. If you have questions about what you heard on today's show or estate planning in general, be sure to call Steve's office in Bellevue to schedule your free no-obligation consultation. Call Steve at 425-455-6788. That's 425-455-6788. And remember, you can always listen to today's or previous programs by going to waltar.com. That's WALTAR.com. Have a wonderful rest of your weekend. And be sure to join us again next Saturday morning from 8 till 9, right here on 820 AM KGNW.